Today we are going to have a discussion with two our esteemed guests, Ms. Karishma Vora and Arpinder Singh. Both of them are esteemed leaders in their area of expertise. To start with, I'll first introduce Ms. Karishma Vora. So Karishma is a barrister with 39 Essex chambers in UK. She is a multi-jurisdictional lawyer and she is a triple qualified lawyer in India, England as well as in DIFC. She handles multi-jurisdictional investigation related matters, disputes as well as civil fraud litigation matters. She specializes in industries such as mergers and acquisitions, private equity, as well as for fraud and disputes in various sectors such as pharmaceuticals, technology, etc. Then we have our second guest, Mr. Arpinder Singh. He is the head of Forensic India as well as global markets leader. I have a privilege to work with Arpinder for last 13 years. He has a total 27 years of experience where he led the dispute practice. He also helps clients on multi-jurisdictional investigations, forensic accounting and dispute advisory. Arpinder is also a certified fraud examiner as well as the president of the Mumbai chapter of ACFE. So without further ado, let's start getting into this conversation and have a discussion on the leading trends in the legal landscape, technology, as well as the career path of both the experts. So to start with, my first question is to Karishma. So Karishma, to start with, how do you navigate through complex challenges in a multi-jurisdictional litigations and arbitrations? If you can throw us some light on it.
In one word, that will be strategy. And the strategy that one adopts in one jurisdiction does not necessarily apply across board. So knowing your procedure, whether it is procedure in arbitration or procedure in litigation, and which country you're in is really the answer to developing a winning case in a cross-border context.
That's a very fair point, Arpinder. From a forensic evidence point of view, what do you think are the leading practices from the evidence gathering perspective in these multi-jurisdictional matters which just Karishma explained?
I think it's really got complicated. So it's a good question. I think today data is no longer on computers, it's on cell phones. So I think technology has changed the way evidence is gathered, and all the regulations have changed the way evidence could be gathered. So for instance, if today we're doing an inquiry or an investigation, we have to take information from a cell phone. Most cell phones in most companies are privately owned. So you need things like chain of custodies, consent forms, and changes by country because of laws and regulations. So it's extremely complicated because today investigations are not restricted to a country, they're generally cross-border. So if you're doing an investigation which is a large global one across 25 countries, you have to keep data privacy laws in mind. Information is gathered in a particular manner. To add to all the complexity, people have it really fancy nowadays and have bring your own devices. You want a Apple computer, you want this type of computer. Now the problem with that is, what does the company own? And that brings into what information you can get access to. Even when you get a consent form, what information do you get access to within a particular device? Can you get a personal information or corporate information? And I think it gets really complicated trying to segregate all of this. At the same time, I would say, how do you get that information has also become more complicated because devices are more encrypted. The second thing, I recently worked on a case where they had to, there was some data in Europe, there was some data in India, there was some data in other parts of Asia Pac, and we had to all send the data to the US because it was a Department of Justice investigation. Now, we all sat for hours redacting information. Obviously, as a consultant, I loved it because I charged more hours. But I can tell you, it's become really, really complicated, but you have to be super careful because if you're in violation of the law, there's no point doing an investigation because the next investigation is going to be on you yourself.
Now, wow, that's a great insight, but I will move to Karishma on that. So Karishma, from a global landscape where the law is changing and a lot of legal trends are shaping, how do you see technology taking that move? Because it's quite prevalent in forensic, but from a technology point of view, how this legal profession is changing the strides?
What Arpinder has said, just taking on from there, it has become extremely complicated. It is so complicated that no brief that I receive right now is in simple chronological order because of the absolute proliferation of technology. And it's impossible, for example, technology has assisted significantly, but it's impossible to deduplicate documents. For example, if I send you an email, the email that I send from my inbox will be different from the one you receive. And so both of those will go into my bundle of documents, which means I am multiplying what I need to digest as a counsel in order to present to the court. But it has been excellent with reducing the sort of volume of documents that one needs to go through. So all of these documents that Arpinder has found in these jurisdictions, when they, let's say they were, 2.5 lakh or 250,000 documents, bringing them down to maybe 19,000, then getting the juniors on the team to go through them and identifying relevant documents. All of that is what is changing the legal landscape. And it's also affecting what we as humans can and cannot do. For example, can I genuinely read 19,000 documents before preparing for a case, even if I devote my full time to it? So that is changing. But the things that are useful, especially at the junior level, are structure of documents, precedents, whether they are transactional or not, or contentious documents such as pleadings that one puts into court. If I were to ask ChatGPT, and I'm just sort of taking, plugging it out of thin air, give me a precedent for a skeleton argument that I can file in an international, let's say an LCI arbitration seated in London. It will give me a good precedent.
Yeah.
Populating it is where, human intervention is still required.
I think that it's a very great insight which Karishma has given us regarding how we narrowed down multiple documents. But Arpinder, because you are also leading a lot of AI related innovations at EY Forensics, can you give us some examples? How we are investigating and how we are making our investigation more, efficient and less time consuming. And if you can give some practical insights around it, it's a very good insight which Karishma has given. But from an investigation side and how we are helping the lawyers as well in those scenarios.
I think Karishma started a really good point because it's all about a pyramid, right? You have X number of documents, you're trying to distill it down so it's quicker, faster, you can review it. I think the important point is not to miss the smoking gun. So I think what happens with technology is it's a double-edged sword. Use technology, it's a bit of a black box, it runs the information, you get certain information, you submit it to the court or you submit it in a particular proceeding, you suddenly find you've missed a few documents. And either the technology failed you or there was some error or there were some false positives. So it's very important to decipher what are you doing. So today I would say technology and AI has definitely helped the discovery process. Now discovery is called by different names, but it's really production of records. So production of records are done by different regulations in the UK, done by different regulations in the US and in India. And the question is, what technology can you use? So there is technology which is called technology assisted review. There are a lot of softwares out there where you put it in a system, you put a particular model. So it could be a bribery and corruption case, it could be a kickback case, it could be insider trading, it could be antitrust, whatever the model is. And the system itself reads, learns, and is able to give you a production of records, which you can then today review and produce. The risk in that is that, have you missed something? So I always I prefer continuous learning models as of today, which is kind of a hybrid, where you put X number of documents, you control the keywords. So you know what has gone into the production, but the program is learning. So there is a continuous learning. So you get the benefit and you get a limited size of documents which you can review. So yes, technology has definitely helped. I remember 10 years back, we used to have 100 lawyers or paralegals going through huge reels of information. Today, you need maybe 2 paralegals doing quality reviews and all the information is done within 2 weeks, what used to happen in 6 months. So yes, the whole process has been changed because of technology and AI. Today, there's the technology and software where you can actually check forgery of a document using technology, which never happened earlier. I mean, you can actually pass millions of documents through software and it tells you this is a fake document, this is a true document. So the use cases are many, and yes, it's changed the way we do business.
So we have a lot of discussion around the AI and technology in legal, but because you two are very senior in the industry, one from the legal front, one from the forensic front. So I'll start some career related questions. I'll start with Karishma. So Karishma, can you give us some glimpse of your journey to become a UK barrister?
Sure. So I started my career at the Bombay High Court, 6 years at the Bombay High Court, including an article clerkship, as we used to call it in those days. And I moved to London in 2009. So it's been 15 years in London. Of course, law is very jurisdiction specific, and this takes us back to the first question about how do you really develop, what is the most important thing in developing a strategy across the jurisdictions. So requalified in London, but that isn't enough because, of course, you're only, even though you have kind of 6 years, you're still 1 year into the legal profession in a different jurisdiction, because practice there's a reason why we call it the practice of law. So requalified as a barrister at Gray's Inn. I got pupillage at a chambers called Fountain Court Chambers, which is specialized in cross-border banking and financial disputes. And over the course of all of these years, have had the great privilege of working with some fantastic English and really veteran lawyers who were kind enough to teach me and kind enough to change my drafting, if I might call it, from Indian English to English English, which was a significant part of the drafting journey, because written advocacy is just as important as oral advocacy. And also gained some experience in cross examinations. So when I moved, I had a lot of applications experience, which is what the Bombay High Court gave us as juniors, and moved to London and did about 150 trials within a span of 2 years at one of the lower courts in England, which was useful to hone the skills. And then, of course, now I'm at 39 Essex Chambers with a brilliant camaraderie and set of colleagues.
No, I would like to pick on the cross-examination thing because that is something which we discussed.
Yeah.
So what advice you want to give to the new lawyers from the cross-examination perspective? Well, that's a really interesting, experience from a starting lawyer perspective. How do you got
Yes.
trained in cross-examination?
I think it depends which jurisdiction you are in, and if you have the privilege of getting into a fantastic set of chambers, but that does very high value cases, it's unlikely that you will get cross-examination experience in perhaps the first decade of your practice. And therefore, it's important to go down to the lower courts, whichever jurisdiction it might be in, a court that gives you cross-examination experience. Take that time out, whether it's 6 months or a year and a half, but do as many trials as you can. We've also started at the Bombay High Court. It's the first High Court in India that follows the same advocacy training method called the Hempel method, which I had to undertake as a barrister in order to qualify as a barrister of England and Wales. And that's also up for applications should anyone viewing this be in their first 3 years of practice to undertake. It's training, and training also gets you at least started on the tips and tricks of how to approach a cross-examination.
Very. Then moving on to yourself. So how your journey looks like, being a chartered accountant and then moving, becoming a head of practice and leading at a global level now. So if you have some advice for the,
I would say, obviously CA is fundamental, or chartered accountancy is fundamental to who I am. I think constantly adding to my technical capability is one thing which I think helped me or kept me aside from others. So I did my law, only education, didn't qualify as an advocate, but that helped. I did my master's MBA in the US, doing it in a different jurisdiction. And then obviously when you're practicing as a financial controller in the US, you have to do your CPA too. So kind of doing my CA equivalent in the US, doing my law, I think made me technically much more confident. So it made me more confident while I did investigations, because they're very technical matters. You need to understand some bit of the legal terminology along with finance, accounts, etc. So it made me a bit better in dealing with crisis, helping clients through their problems. Also having cross-jurisdictional experience, having worked for 9 years in the US, worked in India, done a lot of work in the UK, I think it also helps clients understanding where they come from, because there's a jurisdictional legal issue, there's also a cultural issue in the way people perceive. For instance, production records is a great example. Laws may allow production records, but there's certain jurisdictions they just don't do it. I think in India, for instance, in arbitration, I don't see production records happening all the time. So I think it varies based on jurisdiction, but it made me much more effective in giving counsel. At the end of the day, as we believe in consulting, you have to be a trusted advisor. And only way you can be a trusted advisor is if you bring some technical skills to the table. You're fairly pragmatic and you're able to help the client through their problems. And I think that's what helped me get to where I am. I love my global markets role because it again gives me global visibility. I'm allowed to work in different countries, and it just keeps you sharper as you become more aware. There are new laws coming out in different countries, you become more aware of them. It just makes you more competent, I think.
That's a very, I think, very, insightful. To wrap up the discussion, I have one last question to both of you. Now on, what advice you would give to a lot of legal counsels and the general counsels to beat the challenges in the litigation, arbitration, as well as compliance going ahead?
Take legal advice at the right time. It really makes a significant difference. For example, if there is stress that a party is seeing and they come to me at the time that they are seeing it, rather than when they've already exchanged pre-action correspondence, said things perhaps in pre-action correspondence unknowingly that has weakened their case, have taken steps to initiate whether it's an arbitration or a court case, and then it comes to me, because then there's a lot of unraveling that needs to be done. Likewise, if there are parallel proceedings going on in different jurisdictions, to always have legal teams aware of what is happening in the other jurisdiction, in order to strengthen the overall case and the overall strategy.
I fully agree with Karishma that I think planning is the most important, and I think that sometimes I've seen people not do that perfectly. You tend to rush. I find good lawyers are always very busy, so sometimes you get someone who spends a lot of time with you, but otherwise I find it's a bit rushed. And I think that's one thing I've seen always lands up in problem if you don't understand the case properly and you're giving advice based on limited information or based on your experience, which may not hold stead in this particular case. Second thing, I've always been curious in arbitrations. Obviously, I'm educated as a lawyer. I don't practice as a lawyer, but I'm more an accountant. I find it very curiously that people argue more around the law rather than the facts. And you have expert witnesses, but I feel there's very little work done around the facts. I find it's much more around the law. The facts are just you want a valuation number or a quantification of damages number. But I think if lawyers spend more time on the facts rather than the law, I think you could get an edge in your arguments, you can get an edge in your litigation. So I think it's very important to spend a little bit more time on the facts is one thing I've seen, but maybe I'm getting older and it's being a bit cynical.
I would agree with Arpinder. Facts. I think facts are what win the case, frankly. So I'd agree with Arpinder.
Yeah. Thanks a lot for the nice conversation and insightful conversation on the technical as well as legal side, what general counsel should do, and also the great advice by both the senior experts for the budding forensic accountants as well as budding lawyers. Thanks a lot.
Thank you.